start. Learned Counsel for the petitioner has submitted that, given the dicta of the Supreme Court dated 13 September 1996 entitled Jahar Singh versus Union of India and others, the petitioner's candidature could not have been cancelled by the respondents. In this case, cancellation of Jahar Singh's candidature for appearance for the PO and RMS accountant examination was challenged. Jahar Singh had been granted unqualified and unconditional permission to participate in the examination, and he had also been informed that he had qualified for the post. The Supreme Court noted that the respondents had been unable to produce any rule or circular which empowered the respondents to cancel his candidature. The tribunal had set aside the order cancelling the candidature of the petitioner, yet had not granted relief. It was in this background that the Supreme Court had accepted the appeal filed by the Jahar Singh and had directed the respondents to grant the benefit to him. No principle of law, as urged by the petitioner, has been laid in this judicial pronouncement. The judgment has been rendered in the facts of the case we have noted here too before. It is an admitted position before us that the petitioner was awarded in censure. There is a mandate in para 38 within bracket F of AFO 3 of 2008 that the censure awarded to him was mandatorily required to be taken into consideration by the competent authority for considering his suitability for commissioning. The competent authority would be the authority considering the petitioner's candidature for issuance of the offer of appointment. In the instant case, no offer of appointment had been issued to the petitioner. It was at this stage that the respondents arrived at a finding of unsuitability of the petitioner for commissioning and rejected his candidature. No right, therefore, would flow in favor of the petitioner merely because the respondents had overlooked para 38 within bracket F while considering his application and permitting him to participate in the examination and interview. The tribunal has noted that the record showed that the subordinate officer had erred in making the recommendations of the case's petitioner. The respondents have stated that the petitioner was permitted to apply for the written as well as the Air Force Selection Board interview due to oversight of understanding of AFO 3 of 2008 by the Board of Officers completed at the station level. This was pointed out by the Directorate of Intelligence, and remedial measures were taken, resulting in cancellation of the petitioner's candidature. The record of the respondents includes the inputs received from the Directorate of Intelligence, which are also against the selection of the petitioner. The record of the respondents shows that an inquiry was conducted with regard to the recommendations of the petitioner's candidature by the station commanding officer as well as the board of officers, and the possibility of misinterpretation of the applicable Air Force orders which may have resulted in the recommendation of the petitioner's candidature. Over.